Welcome to the deep dive. Ever wonder about the legal stuff behind, say, your car loan, or even big business deals? Well, you're in the right place. Today, we're slicing through the jargon to really understand secured transactions. It's like the legal glue you've definitely bumped into, maybe without knowing the name.
Exactly. It's really fundamental in finance and law. It basically decides who gets what and when, especially if someone can't pay up. We'll unpack the rules, the ones that protect both sides, borrowers and lenders, and show you why it's so relevant if you've ever bought anything on credit.
Okay, so our mission today is to take these, let's face it, complex legal ideas and make them super clear, really relatable, using the great sources we have. We're going to cover what a security interest actually means, how you create one, how you make it official against everyone else, and, what happens if things go wrong with a loan. Get ready for some real aha moments, I think.
Wrong.
All right, let's kick things off. When we say secured transaction, what exactly are we talking about? It's usually about credit, right? Someone buys something on credit, but the seller or lender wants, well, more than just a pinky promise to pay back.
That's the core of it. And
Yeah.
that's something extra. That's the security interest.
Mm-hmm.
Think of it as a specific limited right a creditor gets in certain personal property owned by the debtor. We call that property the collateral. And this
Yeah.
it's powerful. It means that the creditor can actually take that property, repossess it if the debtor doesn't make their payments. That's why, when you finance a car, the lender has a security interest in that car. Same for big appliances op.
Right, so just lending a buddy $20 based on their word, that's definitely not this kind of secured transaction. You need that specific claim on property.
Precisely. And making that claim solid involves two really key steps: attachment and perfection.
Mm-hmm.
Attachment, that's the first one. It makes the security interest legally real between the debtor and the creditor. So if the debtor defaults, boom, the creditor has a direct right to that collateral against the debtor.
Okay, attachment connects the creditor and debtor to the collateral. Makes sense. But you mentioned perfection. You said that's what really gives the creditor solid footing against, well, everyone else. Why is that so critical?
Yeah, perfection is, well, it's crucial. Because attachment on its own, it doesn't protect the creditor from other people who might also have a claim on that same collateral,
Yeah.
like another lender, or maybe someone who buys the collateral later. Perfection is like putting up a big public sign, a legal billboard, as you said. It announces to the whole world, hey, I have a claim on this property. Without it, even with your agreement, someone else could potentially file their claim, perfect their interest, and jump ahead of you in line if things go south. It turns a private agreement into a public right.
That legal billboard idea really sticks. Okay, let's walk through that example from the sources, piece by piece. It really shows how this builds. So imagine, creditor lends debtor money to buy office furniture. Debtor signs a security agreement saying that furniture is the collateral.
Okay.
Then debtor uses the money, buys the furniture. Now, the security interest attaches. Why? Because 1, they agreed in writing. 2, the creditor gave value, the loan money. And 3, the debtor now has rights in the furniture they just bought.
Makes sense. All three conditions met.
Right. So at this point, if the debtor defaults, the creditor can go after the furniture. But maybe not successfully if, say, another creditor also has a claim and perfected it.
That's the risk without perfection.
Exactly. So the smart creditor then perfects the security interest, usually by filing what's called a financing statement, a public record. Now, if the debtor defaults, the creditor's claim on that furniture is strong against the debtor and most other third parties. See how it layers up. First attachment, then perfection for full protection.
It's a clear progression. And just to be clear what we're talking about, scope-wise, this whole system is governed by Article 9 of the Uniform Commercial Code, the UCC. It mostly covers these agreements where you use personal property as collateral, things like goods, equipment, inventory, even fixtures, which are items attached to real estate like built-in cabinets. It also covers outright sales of accounts receivable, basically, money owed to a business.
Okay, so personal property, fixtures, accounts, what's not covered then?
Good question. Crucially, Article 9 doesn't generally cover security interests in land itself. That's mortgage law, a whole different area. It also doesn't cover things like wage claims or liens that arise automatically by law, like a mechanic's lien on a car they repaired.
Why the exclusions? Is it just historical reasons?
Yeah, largely historical context and the fact that there are other specific laws designed to handle those areas, like real estate law. So the bottom line for listeners, if you're dealing with a car loan, business equipment financing, inventory financing, or even selling your invoices, Article 9 is your rule book.
Got it. Okay, we've got the basics down. But now let's get into something really interesting. You hinted at a special type of security interest that gets, like, VIP treatment, the purchase money security interest, or PMSI. Why is this one such a big deal?
The PMSI. Yes, it's a very big deal because it gets super priority. If it's properly perfected, a PMSI can often leapfrog all other security interests in the same collateral, even ones that were perfected earlier.
Whoa, okay. Super priority. How does one get this special status?
It arises in only two specific situations. First, if a seller finances the purchase. So the creditor sells a collateral to the debtor on credit and keeps a security interest for the purchase price. Think buying a couch from a furniture store on their store credit plan.
Okay, seller financing. What's the second way?
The second way is if a lender provides the money specifically for the debtor to buy the collateral. The key is that the loan funds must actually be used by the debtor to acquire that specific collateral. So the lender doesn't have to be the seller, they just have to provide the purchase money.
Let's nail this down with those Becky examples. They really clarified it for me. Example 1. Becky buys a $1,000 stereo from Radio Hut on credit from Radio Hut. Radio Hut keeps a security interest.
Does Radio Hut have a PMSI?
Yes, because Radio Hut provided the credit that allowed Becky to buy that specific stereo. They were the seller financier.
Perfect. Example 2.
Becky wants the stereo, but gets a $1,000 loan from a bank specifically to buy it. She takes the cash, buys the stereo from Radio Hut, and gives the bank a security interest.
Does the bank have a PMSI?
Yes, again, because the bank advanced the funds that were actually used to purchase the collateral.
Right. Now the third scenario.
Becky needs $1,000. She goes to the bank and offers her stereo, which she already owns, as collateral for the loan.
Does the bank have a PMSI this time?
No. They have a regular security interest, sure, but not a PMSI, because the loan money wasn't used to buy that stereo. She already had it.
Exactly, you've got it. So the easy test, the sort of pass key here, is just ask, did the debtor buy this collateral using the creditor's money or the creditor's credit? If yes, it's likely a PMSI. That purchase link is everything.
That makes perfect sense. Okay, so we know about security interests, we know about PMSIs, but what kinds of property can actually be collateral? You mentioned personal property, but let's dive deeper because apparently the type of collateral really matters for the rules.
It absolutely does. The rules for how you perfect your interest, or even where you file, can change depending on the type of collateral. Under Article 9, we generally put collateral into 4 big buckets: goods, intangible and semi-intangible collateral, investment property, and proceeds.
Let's focus on goods first. That includes things like consumer goods, inventory, equipment. But here's the mind bender you mentioned. The category depends entirely on how the debtor uses the item, not the item itself.
That's the crucial point. It's all about the debtor's primary purpose for that item at the time the security interest attaches. Let's use that classic car example again. It really drives the point home. If a debtor, say a small business owner, uses a car mainly for making deliveries.
Then it's equipment, right, business use.
Exactly, equipment. But if that same person uses the exact same car, primarily for personal driving, family errands, commuting.
Consumer goods, for personal, family, or household purposes.
Spot on. And if the debtor is actually a car dealer, and they buy that car specifically to resell it on their lot.
Then it's inventory, held for sale.
Precisely. The same physical object, a car, can fall into 3 different classifications based purely on the debtor's use. And that classification dictates things like perfection rules, especially for PMSIs.
Wow. That's a huge takeaway. Use dictates classification. So important. Okay, what about the other categories, just briefly?
Sure. Intangible collateral accounts. Think of accounts receivable. It's the right to be paid money for goods sold or services rendered, where there isn't a specific piece of paper, like a check or promissory note representing that right, like the money your dentist is owed after you visit.
Okay, rights to payment.
Then investment property. That's fairly straightforward. Stocks, bonds, mutual funds, brokerage accounts.
Got it.
And finally, proceeds. This is whatever you get when you sell, trade, collect, or otherwise dispose of the original collateral. If the collateral was inventory, the cash or accounts receivable you get from selling it are proceeds.
Okay, that makes sense. So goods, intangibles like accounts, investment property, and proceeds. And for goods, remember, use is key. All right, we've got the landscape mapped out. Let's circle back and dig deeper into those 2 pillars you mentioned, attachment and perfection. We need these for the security interest to be effective. Remind us, what are the absolute must-haves for attachment?
Right, the bedrock. 3 things must happen for attachment. 1, there has to be an agreement creating the security interest. Usually this is a written security agreement signed by the debtor that describes the collateral. Or it can be oral if the creditor actually has possession of the collateral, the old-fashioned pledge, like at a pawn shop.
Agreement, check. What else?
2, the creditor has to give value. This is usually the loan money itself or the goods sold on credit.
Value given, check.
And third, the debtor must have rights in the collateral. You can't grant a security interest in property you don't own or have rights to.
Agreement, value, rights in the collateral. Got it. Now, something you mentioned earlier was fascinating, these after-acquired property clauses. How do they work?
Ah, yes. These are very common, especially in business lending. A security agreement can state that the security interest attaches not only to the collateral the debtor owns now, but also to collateral of the same type that the debtor acquires later. So, if a store gives a security interest in its current inventory and after acquired inventory, the lender's interest automatically attaches to new inventory the moment the store gets rights to it. It saves having to redo the agreement every time new stock arrives.
That's incredibly efficient for lenders dealing with fluctuating assets like inventory or accounts receivable.
Definitely. Okay, so once attachment happens, we move to perfection. As we said, this is about getting priority against other claimants, maximum priority.
Right. And the key rule you mentioned, perfection can't happen before attachment, but they can happen simultaneously. So how do creditors actually do perfection?
There are 5 main ways to perfect. The first, and by far the most common for many types of collateral, is filing.
Filing what, exactly? The whole security agreement.
Usually not. It's typically what's called a financing statement, often referred to as a UCC-1 form. It's a simple notice filed in a public office, usually the Secretary of State's office where the debtor is located. It just needs the names and addresses of the debtor and secured party, and an indication of the collateral covered, sometimes specific, sometimes by type, like all equipment or all inventory. It puts the world on notice.
And you can file this even before the loan is made or the security agreement is signed.
You can file it ahead of time. Perfection then occurs automatically the moment attachment happens when all 3 conditions, agreement, value, rights, are met. It lets lenders secure their priority early.
Okay, filing is number 1. What's next?
Second is taking possession of the collateral. This is also called a pledge. Think pawn shops again. If the creditor physically holds the collateral, their interest is perfected. You can perfect security interest in goods, instruments, money this way. Obviously, you can't take possession of something intangible like an account receivable.
Right, makes sense. Possession. Method 3.
Third is control. This method is specifically for certain types of collateral, most notably deposit accounts, like bank accounts, electronic chattel paper, and investment property.
Control. How does that work, especially for something like stocks in a brokerage account?
It means the secured party has taken steps so they can basically sell or dispose of the collateral without needing any further action from the debtor. For a brokerage account, like in that Alex Bank Squab example, the bank perfects by control if Alex tells his broker, Squab, to follow the bank's instructions regarding the account. Or if the bank becomes the actual account holder, it gives the bank direct power over the asset.
Ah, okay. So it's about having the practical ability to deal with the asset. Filing, possession, control. What's method 4?
Method 4 is automatic perfection. This is the cool one. Perfection happens automatically the moment the security interest attaches. No filing, no possession, no control needed.
Set it and forget it. What gets automatically perfected?
The most significant one for our discussion is a purchase money security interest, PMSI, in consumer goods. And this is critical. Only PMSIs in consumer goods get automatic perfection. If you have a PMSI in inventory or equipment, you still need to file a financing statement to perfect it. Big difference there.
Okay, that's a super important distinction. PMSI in consumer goods, automatic perfection. PMSI in anything else usually requires filing. Any other common automatic perfection?
Small-scale assignments of accounts receivable sometimes get automatic perfection too, but the PMSI in consumer goods is the main one to remember.
Got it. And the 5th method?
The 5th is temporary perfection. These are situations where perfection is granted automatically, but only for a limited time. There are 2 key scenarios here. First, a 20-day period for proceeds. If collateral that was perfected is sold or traded, the creditor automatically has a perfected security interest in whatever the debtor received, the proceeds, for 20 days.
Like the Sally stereo example. She trades in her old stereo, collateral, for a new one.
Exactly. The bank's interest automatically attaches to the new stereo, and it's perfected for 20 days. To stay perfected beyond 20 days, the creditor usually needs to amend their financing statement or take other steps, unless the proceeds are identifiable cash proceeds or meet other specific rules.
Okay, 20 days for proceeds. What's the other temporary perfection?
The other is a 4-month grace period if the debtor moves to a new state. If a security interest was perfected by filing in State A and the debtor moves to State B, that perfection generally remains effective for 4 months after the move. The creditor must re-perfect in State B within those 4 months, usually by filing a new financing statement there, to maintain continuous perfection and priority. If they don't, they lose their perfected status.
4 months to catch up if the debtor moves states. Okay, that covers the 5 methods: filing, possession, control, automatic, and temporary. So we've built the structure, attachment, perfection, but what happens when it all breaks down? When the debtor defaults, can't make the payments? This is where the security interest really shows its teeth, right?
Absolutely. This is the enforcement stage. And the secured party's main right, the most important one, is the right to take possession of the collateral and sell it to try and recover the debt.
Taking possession, how does that actually happen? Is it always like those dramatic repo scenes on TV?
Sometimes, maybe. There are two main ways. The first is self-help repossession. The creditor can just go and take the collateral, like a car, without going to court, but, and this is a huge but, only if they can do it without breaching the peace.
Ah, breach of the peace, that's the key phrase. What does that mean, practically?
It generally means no violence, no threats, no breaking into locked garages or homes, no trickery, no confrontations likely to cause a disturbance. If the repo agent has to argue with the debtor, or if the debtor clearly objects, they usually have to back off to avoid breaching the peace.
So if they can't grab it peacefully.
Then they need to use the second method,
Mm.
a judicial action called replevant. They go to court, get an order, and then the sheriff or other law enforcement officer assists in seizing the property legally.
Okay, self-help if peaceful, otherwise court order. Once the creditor has the collateral, what then? They just keep it.
Usually they sell it. The sale could be public, like an option, or private. But here's another crucial debtor protection. The sale must be commercially reasonable.
Commercially reasonable. What does that entail?
It means every aspect of the sale, the method, the advertising, the time, the place, the terms must be reasonable, designed to get a fair price under the circumstances. You can't just sell a $20,000 car to your cousin for $500.
That prevents the creditor from just dumping the asset unfairly low.
Exactly. And generally, the creditor has to give reasonable notice of the sale to the debtor and any other secured parties who have filed claims on that collateral, so they have a chance to monitor the sale or even bid.
What's the effect of a proper sale? Does it clear things up?
It does. A commercially reasonable sale basically wipes out the debtor's rights in the collateral and also the rights of any secured parties or lien holders who had lower priority than the selling creditor. Someone who buys the collateral in good faith at the sale gets it free of those subordinate interests, but they still take it subject to any interests that were senior to the selling creditor's interest.
Okay, the sale cleans the slate for lower priority claims. But before that happens, does the debtor have any last chance to get the property back?
Yes, they do. It's called the right to redeem. Up until the moment the creditor actually sells the collateral or enters into a contract to sell it, the debtor can get it back by paying everything owed, the full remaining debt, plus any repossession and sale preparation costs.
Pay it all off, get it back, but that right disappears once the sale actually occurs.
Correct. The sale cuts off the right to redeem.
So the sale happens, where does the money go?
There's a strict order of distribution, like a waterfall. First, the proceeds pay the expenses of the repossession and sale towing, storage, advertising, auctioneer fees, reasonable attorney's fees, if the agreement allows.
Okay, costs first, then.
Second, the money goes to pay off the debt owed to the secured party who conducted the sale.
Makes sense. What if there's still money left after they're paid?
Then it goes to pay any subordinate secured parties who made a formal demand for payment in order of their priority.
And if, miracle of miracles, there's still money left after all expenses and all secured debts are paid.
Then the surplus goes back to the debtor.
Okay, that's the ideal. But what if the sale doesn't bring in enough money to even cover the expenses and the main debt?
Ah, that's the flip side. That shortfall is called a deficiency. And in most cases, the secured creditor can then sue the debtor personally for that deficiency amount.
So you could lose the collateral and still owe money. That seems tough.
It is tough, but legally, the collateral was just security for the debt. The underlying obligation to pay the full amount remains if the collateral doesn't cover it.
Is selling the collateral the only option after repossession?
No, there's an alternative called retention of collateral, sometimes called strict foreclosure. The secured party can propose to just keep the collateral in satisfaction of the debt.
Just keep it and call it even.
Well, it depends. In non-consumer transactions, the creditor can propose to keep it in full satisfaction, dead gone, or partial satisfaction, meaning they keep the collateral and might still pursue the debtor for a deficiency.
Okay, flexibility for business debts. What about consumer debts?
For consumer transactions, there's more protection. The creditor can only propose to keep the collateral in full satisfaction of the debt. They cannot keep the consumer goods and still sue for a deficiency. They have to choose: keep the goods and walk away, or sell them and potentially pursue a deficiency.
That's a significant protection for consumers. Do they have to notify anyone if they want to just keep the collateral?
Yes, absolutely. They have to send notice of their proposal to the debtor and, in some cases, to other secured parties. If the debtor or another party objects within a certain time frame, the creditor must sell the collateral. They can't keep it.
And isn't there a special rule if the debtor has paid a lot already on consumer goods?
Yes, the 60% rule. If the collateral is consumer goods and the debtor has already paid 60% or more of the cash price for a PMSI, or 60% or more of the loan amount for a non-PMSI, the creditor cannot just keep the goods, even in full satisfaction. They must sell the collateral within 90 days after repossession, unless the debtor agrees otherwise after the default. This forces a sale to see if there might be a surplus for the debtor who has significant equity built up.
Another important safeguard for consumers prevents the creditor keeping something that's mostly paid off. Is there any other path besides repossession and sale or retention?
Yes, the creditor can always choose to ignore the collateral initially and simply sue the debtor on the underlying debt, get a court judgment, and then use standard judgment enforcement procedures, like having the sheriff levy on the debtor's assets, which could include the collateral, to satisfy the judgment.
So just a straight lawsuit for a money owed?
Exactly. They don't have to go through the Article 9 repossession steps if they don't want to.
Wow. Okay, we have really journeyed through the world of secure transactions today, from defining that core concept, the security interest,
To the vital steps of attachment, making it real between the parties.
and perfection, making it strong against the world, using methods like filing or possession or control.
Not forgetting that VIP, the purchase money security interest, with its special priority.
And understanding how collateral type, especially how goods are used, changes the rules.
All the way through to the consequences of default, repossession, sale, redemption, deficiencies, and retention.
It really does provide a much clearer lens for understanding how so much of our credit system works, doesn't it? What really stands out to you, looking back over all this?
I think what stands out is how this framework, while complex, tries to balance the creditor's need for security with the debtor's rights and protections, especially for consumers. And connecting this to the bigger picture, maybe the provocative thought for our listeners is this: how does understanding these detailed mechanics, attachment, perfection, priority rules, default rights, change your perspective when you next take out a loan or finance a purchase or even just read about business finance in the news? Does knowing the rules of the game empower you?
That's a great question to ponder. Knowing the structure definitely demystifies a lot. Thank you so much for joining us on this deep dive today. Keep exploring, keep questioning, and keep learning.